Thanks, Lisa, and thanks, everyone, and thank you for having me. It's my first time to Bond, and I don't want to leave. So what a great place, so thanks very much. I'm going to be talking about something that's related to the integrity of sport, but in my view doesn't equate to the integrity of sport, and that is player health, safety and welfare. And we've had a number of presentations this morning that have already talked about, in particular, the doping scandal at the Essendon Football Club, which has been largely viewed as an issue of the integrity of the game. I'm going to again talk about that case study, but I'm going to view it as primarily a player health, safety and welfare issue. On this slide, there's a collage of photos, and all these photos share one thing in common. They involve tragedies that involved professional sports people. We have had the tragic accident to Alex McKinnon, the rugby league player. We have had 4 female jockeys die in the last 18 months. The death of cricketer Philip Hughes. We have had serious bullying allegations in the Australian swim team. We had hallucinating inducing heat at the Australian Open. There's a photo of a player that collapsed after swearing that he was hitting the ball to Snoopy. And obviously we've got the supplement scandals in the Essendon and Cronulla Football Club. Numerous investigations have been held into each of these incidents. Investigations by the clubs involved, investigations by the governing bodies, investigations by regulators such as ASADA, but only in one instance have there been investigations by the work health and safety regulators, and they were the deaths of the female jockeys. All the other incidents haven't been investigated from a work health and safety perspective. I say that, but we shouldn't be surprised. I did a search of all the websites of the Australian work health and safety regulators, and there is not one mention to professional sport. I went and looked at the websites of all the sports regulators, and if I use regulator broadly there to include the institutes of sport and the Australian Sports Commission, there is no reference to the application of work health and safety laws to professional sport. So we shouldn't be surprised by this disconnect. And what I'm going to be talking about today, and I talk about in my paper, is trying to understand why we have this disconnect. And what I'm going to do is explore a number of different narratives that potentially explain it. And I'll examine those narratives and in some cases debunk those narratives, or at least attempt to debunk those narratives. I am going to use Essendon's supplement saga, though, as my primary case study for 2 reasons. One, the Essendon Football Club and the AFL are representative of how team-based professional sports are organised in this country, so therefore it's a useful case study for that point of view. Second, though, it provides a useful factual matrix within which to explore these issues. I put the matrix forward not as a definitive statement of its accuracy, but as the matrix that is predominating the debate on this issue. And I'm primarily relying on the Switkowski report that Essendon itself commissioned. A report that said there was a pharmacologically experimental environment. A report that said all standard governance practices, accountability practices, management practices had broken down. A report that said that there was use of external doctors and suppliers outside established guidelines. So I'm going to be using that as my factual matrix together with the frenzied media reporting that has questioned the legality, efficacy and health effects of these supplements. So with that as background, as I said, I want to explore a number of narratives. And the first narrative that I want to explore is this concept that sport is not work, and professional sports people in particular are not workers. This narrative that sport is what we do when we're not working. We don't call players workers. We don't call the playing field their workplace. So we have this narrative out there that sport is not work. As a matter of law, though, I want to put to you in work health and safety law that it is unequivocal that professional sport is work subject to work health and safety laws. It's not just enough, though, for there to be an employee-employer relationship. The employee has to be engaged in work when the injury occurs for the employer to be responsible. Employers are not responsible for injuries to employees when they're engaged in non-work activities. But the way that work is defined, it's defined in a manner that includes activities that involve physical and mental effort, the application of special skills, activities for which you are paid, that are part of a formal and structured organisation directed or controlled by others. And I would say, particularly in a team environment, professional sports people playing in a team environment are clearly workers, are clearly engaged in work. It's also clear from an analysis of the workplace and health and safety laws themselves. They actually carve out exceptions for things such as plant designed in sporting activity have special rules. Prevention of falls regulations have special rules for sport. You wouldn't need those special rules if sport wasn't otherwise covered. So the starting premise I have is that I do believe it is unequivocal that professional sports people are covered by workplace health and safety laws. I'm not going to go into amateur sport. That's a whole other area and a much greyer area, but we're just going to focus on professional. And once we conclude that professional sport is work, then a number of duties and obligations are enlivened under the work health and safety laws. And I'm basing this on the New South Wales laws, which are basically the same in Queensland, Northern Territory, like same everywhere except for Western Australia and Victoria. It's probably easy to put it that way. And so the first people that owe duties are the clubs, the sporting clubs that employ. And they owe a duty to ensure, so far as is reasonably practicable, and I'll come back to that, the health and safety of workers working in the undertaking, working for the club. And I won't go through, read the whole slide, I'll just let you have a quick look at it, but what you can see is also governing bodies and tournament organisers also owe duties. Directors and officers of football clubs owe duties, although if you're a volunteer, you can't be prosecuted. But a lot of officers of sporting clubs aren't volunteers. So while the directors of many sporting clubs are volunteers, the chief executives, the senior managers, the head coach, all probably fall under the definition of officer. Designers and manufacturers of plants and substances. Substances is defined in a way that clearly covers supplements given to players. Venue operators and even spectators owe duties to ensure that they take reasonable care for others at the workplace, including the players. So there's a broad range of duties that are owed. These duties are concurrent, overlapping and non-delegable. The fact that someone else owes a duty with respect to the same activity doesn't excuse you from any responsibility. Risk to health and safety is defined broadly. It includes not just the occurrence of an accident, but the mere possibility of an accident is a risk. Health includes physical health and psychological health. It's very broad. But the duties are qualified by, most of these duties are qualified by the word reasonable, either reasonably practicable, reasonable care, or reasonable steps. And that brings me to the next narrative that I want to explore, and this is the narrative that somehow different rules apply to sports culture of risk. And we do see that in a number of areas of law, different rules do apply. Criminal law has a defence of implied sporting consent. Negligence laws tend to place most of the risk on the participant. Workers' compensation laws have a broad carve-out for professional sport, as do discrimination laws. So we see that many areas of law do have different rules to sport and accounting for sports culture of risk. But work health and safety is not one of them. The same rules apply and the same legal principles apply. However, what those legal principles also say is that the rules need to be applied pragmatically. The courts have said you apply the rules as practical people, you apply them pragmatically, taking into account the nature of the activities that are being taken place. Now, so in that context then, we could differentiate between two types of sporting activities. On this slide, I'm representing the sporting contest. Contests that are inherently risky, inherently dangerous, either because of the speed, the intensity, the collision, the contact involved. And so on one category, I'm putting the sporting contest, the actual contest, as well as simulated contests that might take place in training in more or less similar conditions. And the other activities are the activities that are undertaken by professional sports people other than in the sporting contest. Activities that are taken training, dietary activities, conditioning activities, activities representing the club at cultural, community, social events. And you'll see in the top of that column, I've also got the injection. Activities that might be taken in medical rooms, in offices. The way the work health and safety law operates is what is reasonably practicable in the circumstances would take into account the rough and tumble of the sporting contest. We would apply the law pragmatically, allowing for the greater risk that is involved in sporting contests. That doesn't mean that you don't have a duty at all. It just means that the duty has to take that into account. So in determining the rules of play, rules about concussion, head contact, conditions of play, heat policies, the state of the pitch, the equipment you use would all have to be designed in a manner that, to the extent reasonably practical, guards against the risk. However, when we go to the other activities, the activities that take place away from the sporting contest, my argument would be there is no basis upon which to treat workplace health and safety duties differently than you would treat the duties if you were applying it in an office of a construction company or the office of a manufacturing company. If you're on a mine site, why would you treat duties that occur in gymnasiums, offices, medical rooms differently than you would treat them in like places in other industries? And there doesn't seem to be the basis, in my view, to treat them differently in that context. So to me, the point I want to make here is different work health and safety rules don't apply to sport, but they have to be applied pragmatically, and that would take into account the rough and tumble of the game, but not activities that take place elsewhere, not between combatants on the gladiatorial arena, but take place between people in authoritative positions, head coaches, club officials, and often young, impressionable people entering their life dream. The third narrative is sport's regulatory self-regulatory status. Sport has a kind of a mystique. The law defers to sporting governing bodies. The criminal law is not applied to a brawl on the sporting field in the same way it's applied to a brawl on the street. And we've seen in civil courts that courts are very deferential to the disciplinary tribunals of governing bodies. And so therefore there is an argument that we should just leave work health and safety to the control of the governing body. But there are limitations attached to self-regulation. First, work health and safety, and I don't care what the clubs say and what the governing bodies say when the AFL starts off its punishments to Essendon by saying that our paramount concern is the health and safety of the players, their conduct doesn't demonstrate that. It's not consistent with the rhetoric. Health and safety of the players is not their paramount concern. It is ironic that what happened at Essendon happened under the banner of whatever it takes was their motto for the season. So, how much time have I got? Oh, that wasn't a bell for me. Okay, that wasn't you. Sorry, I thought I was getting the dong. So first of all, health and safety isn't their paramount concern. Second of all, for the governing bodies, their regulatory jurisdiction is limited by their contractual reach. They can only discipline people they have contracts with. And I think I've shown here the reach of the work health and safety laws is much broader and imposes duties on a much broader group of people than just the people with whom the governing bodies have contracts. But the third and most important reason is the governing bodies have a conflict of interest. Again, using Essendon as the example, the AFL itself has a duty to ensure, so far as is reasonably practical, the health and safety of workers working in its business or undertaking. Its business or undertaking is the AFL competition. Now, with respect to drugs and sport, the AFL's done a lot. They've developed a drugs policy. They have medical officers employed and integrity officers employed to enforce it. They run training for players. They do a lot. The question is, as a matter of law, have they done all that is reasonably practicable? The cases in work health and safety law in the franchisor situation, so a fast food chain that franchises its business, tell us that the franchisor has an obligation to ensure that its policies enable work to be safely conducted, that they have a responsibility to monitor those policies, and when informed of breach of those policies, ensure those breaches are rectified. The AFL is akin to a franchisor. It licenses clubs, it licenses players to participate in its business. There was evidence that the AFL was aware that Essendon was engaging in dubious supplement use. They warned, the integrity officer warned James Hird personally about it. And with respect to the failure to follow that up, AFL Chief Executive Andrew Demetriou said at the time, we should have been more vigilant and we regret we didn't do something earlier. And now Chief Executive, then Deputy Chief Executive Gillan McLaughlin said the AFL dropped the ball by not monitoring the Essendon supplement program after advising James Hird to steer clear of using peptides in August 2011. that we weren't out there regularly monitoring is potentially a failing of the AFL. In any other context, that would be activity that would trigger the interest of work health and safety regulators. The fourth narrative is that there are other more appropriate bodies. And both WorkSafe Victoria and WorkCover New South Wales justified their non-involvement in the Essendon and Cronulla supplement sagas by reference to there being another more appropriate body, in particular ASADA. What I'd say about that is two things. One, ASADA's jurisdiction is limited to sportsperson and associated people. Again, their jurisdiction probably isn't as broad as the work health and safety laws, in particular going down the chain to be able to impose obligations on people who were involved in the detailed design and development of the supplements. Second, though, notwithstanding the ASADA legislation says that it regulates doping and safe, let me get the correct language, that it is, now I've lost my place. Its legislation talks about sports doping and safety matters. If you go to the ASADA website, the word safety is nearly missing, it's absent. It's exclusively in the integrity of sport. And so therefore, and their investigation, which had 34 show cause notices on the workers, 34 out of 37 show cause notices on the workers, and they didn't actually focus on the management, the senior executives involved, tells you where its focus is. The focus of work health and safety law is to protect workers and other persons against harm to their health, safety and welfare through the elimination or minimisation of risks arising from work. It's hard to understand how the ASADA investigation best served those objectives. I've now been given the notice about the time. The last two narratives I'll just quickly mention is work health and safety regulators are cautious. They're cautious when they're entering new areas, and they probably should be cautious. But that caution shouldn't justify a policy of inaction. And finally, the other narrative is that sport is not a regulatory priority. And that might be the case in the past, but surely each case should be determined on the merits. And my argument is that if this had happened, imagine in any other industry, imagine in a construction industry, the employer gave their workers supplements to increase their productivity so they could work longer and harder. Imagine in any other industry that the use of that supplements then occupied the newspapers for months on end, and then try to think that the work health and safety regulators wouldn't intervene. Surely it's the nature of the risk and the nature of the action that should determine the regulators' priorities, not the political or social or cultural influence of the body, which is something that Lisa talked about. So in conclusion, let me just say, professional sport is work to which work health and safety laws apply. Different rules do not apply to professional sports, but they need to be applied pragmatically, particularly to the rough and tumble of the game. There is limitations associated with industry self-regulation. Work health and safety regulators are the appropriate bodies to investigate potential work health and safety breaches. Bodies that focus on the integrity of the sport are not the appropriate body. Regulators should exercise caution when entering new fields, but professional sports should not be and should not be perceived to be either above the law or beyond the reach of the work health and safety regulators. And my final point, which I didn't get to talk to in any detail, is that what I ultimately think is required is greater transparency from the regulators to explain what they're investigating and what they're not investigating and why.